Hello everyone, and welcome once again to Prof. Dan Tutorials. Now, with the recent US elections behind us, many are wondering how the results might affect employment-based immigration categories like the EB1, EB2, EB3. So in today's video, we will explore potential changes, current policies, and what applicants, especially you self-petitioners, should anticipate moving forward. So stay tuned to ensure you are well informed about these employment-based petitions. So if you have been finding Prof. Dan tutorials on YouTube really helpful, please don't forget to give it a thumbs up. Sharing is caring, so pass the content along to others who might significantly benefit. And if today is your first time watching this video from Prof. Dan Tutorials, please kindly subscribe so you never miss out on information and insights. As a disclaimer, just a quick note before we dive in. This video, like all my previous contents, is meant purely for informational and educational purposes. It's designed to give you a better understanding of employment-based immigration processes, but it does not serve as a legal or immigration advice. Every case is unique, and if you are considering any significant steps, please consult with a qualified immigration attorney who can address your specific situation. Remember, your decisions are yours to make, and I can't be held responsible for the outcomes. So stay informed and make the best choice for yourself. Okay, so the very first thing we're going to look at is the current status of employment-based immigration categories. So as of now, the EB1 and EB2 categories remain unchanged. Now, the U.S. Citizenship and Immigration Services, USCIS, continues to process applications under existing guidelines. Although there has been several updates. In 2024 alone, USCIS implemented several updates affecting employment-based visa categories. One of it is the Form I-140 fee adjustment. You recall that the filing fee of this form, which is the immigration petition for alien workers, increased from $700 to $715. Additionally, there has been an asylum program fee that was introduced requiring self-petitioners or petitioners of the employment-based category to pay either $0, $300, or $600, depending on your specific situation and criteria. Another important update so far in 2024 is the Form I-140 update. You recall that USCIS has revised Form I-140, particularly Part 1, Question 5 and 6, to determine eligibility for reduced fees. Accurate completion of these sections is crucial to avoid rejection. You can check on Prof. Dan playlist video that has talked severally about all of these videos and updates to help you so as to avoid rejection, which has been the case since these new policies have been introduced. Another important thing is the premium processing fee increase. Of course, the fee for Form I-907, request for premium processing service, rose from $2,500 to $2,805, expediting certain employment-based petitions. Another thing that has happened in 2024 is the EB1 eligibility criteria enhancements. Now, you recall that recently In October 2024, USCIS updated guidance to recognize team awards as evidence of extraordinary ability in the EB1 category, broadening the scope for demonstrating excellence. There are two other amendments made, so please refer again to previous videos or you check right from the USCIS source. Another important update is the processing time updates. Now, USCIS updated processing times for various forms, including Form I-140, informing applicants of expected timelines. Taking people more time to get responses, though. USCIS processing time, as we should know, is that it can fluctuate due to various factors, including policy shifts, resource allocation, and the likes. So my advice is regularly check the USCIS processing times webpage in order to have idea of current estimates. I'm saying this because it's been concerned that many people saying, oh, I've applied, it's been 5, 6, 7 months, I've not gotten any response, and you are concerned, you are so worried. I understand because previous experience of people who have received approval will tell you, oh, I applied and within 2, 3, 4 months, I received response doing ordinary processing, but that's no longer the case as of now. So again, this is due to several factors. Check the USCIS processing page so that you can have peace of mind when you see the estimate and you can be sure that, okay, everything is still right, nothing is wrong or nothing is required from your end other than waiting for USCIS to get a response from them. Another important thing is the public engagement initiatives. Now, USCIS increased outreach efforts to inform stakeholders about changes in employment-based immigration policies and procedures. So my advice would be that you can sign up and, you signing up will help you to stay informed. You can receive emails, they can invite you to their research, things like that, and you can get more information or you can share your experience with them in order for them to make more informed decision as to their processes. All right, so potential policy changes post-election. So what I'm going to say is that why the election results can really influence immigration policies, any significant changes typically require time to implement. So it's essential for you as a self-petitioner to stay updated through the official USCIS announcements. In part on priority dates and visa bulletin. Of course, we do know that the Department of State's visa bulletin outlines priority dates on monthly basis for visa availability. So one would expect that even post-election, these dates may adjust. So I would say keep an eye on the monthly bulletin as you've always been doing so. If there is any updates, we will be here to also alert you so you can be aware if your priority date is current, so you can go ahead for those of you that have approval. So you can go ahead to possibly adjust your status if you are in the US or continue with your consular processing if you are outside the US. Legislative proposal affecting employment-based visas. Now, new legislation can introduce reforms to employment-based visa categories. That is just true. That's fact. Now, as petitioners, monitoring congressional activities and perhaps proposed bills will also help you anticipate if there is going to be any potential changes. Now, my own would be that if you are ready to apply and you know that your expertise will contribute to the U.S. national importance, please go ahead and apply. Don't delay. If your package is complete, you are sure of what you have, please go ahead. Stop procrastinating. And of course, there is role of executive orders in immigration policy. We are aware that presidential executive orders can directly impact immigration procedures. However, something good here about the United States is that such orders often face legal challenges and may not result in immediate changes. You will recall some years back, we read in the news, that was January 2017, I think, there was an executive order that restricted entry to the United States for certain individuals. So anything can happen. But even at that, we also know that courts block part of those kind of order, and it went through several iterations before a revised version was upheld by the Supreme Court in 2018. So what I'm trying to say is that, in essence, whoever wins the election, there can be an executive order. My own is that apply for your EB if you are qualified and you are ready to contribute to the US, so apply. Resources for staying informed. As I've always said in my videos or when I'm trying to share with you valuable information, I always direct you to the rightful source, the legitimate source, which is what is USCIS saying. This will be my advice to you all. Utilize official resources like the USCIS website. You will be surprised. Everything you need is already on the USCIS website. Frequently asked questions, latest news, updates, all of these things are there. Also the Department of State and perhaps reputable immigration law firms. These are official resources that can help you to stay updated on any changes affecting employment-based immigration. It's important to stay up to date. It's very important. For example, you recall again, as I said earlier, in October 2024, there was a policy update for those applying for the EB1 petition. So if you are not up to date, you probably will not know about such updates and you file, you self-petition. You see what I'm saying? So it's important to know what is the latest news. What is USCIS saying at this time, at any point in time that you want to apply for your petition? This is really, really important. And that is it. So thanks for watching. Thanks for sticking with me through this video. I hope the walkthrough helps you stay on top of your petition. Of course, if you found this video helpful, please don't forget to hit that subscribe button for more valuable tips and insights on your petition. Especially, my focus is on employment-based self-petitioners who are doing it by themselves. I do know, we are aware, many of you filing by yourself, you are confused, you don't know how to go about it, you don't know what's up, things like that. And that is why I would advise you check out free videos on Prof. Dan Tutorials playlist on YouTube. You can use all that to get insights, to support your thinking or educate yourself on how to go about it. That would be my advice and my own contribution to the community, because when you are informed, when you know that you can do this, invariably you are also contributing to the US. Since you have a proposed endeavor, you've shown that your proposed endeavor has substantial merits and your proposed endeavor is of national importance. That means you are a valuable asset to the United States. US welcomes you. So apply. You can do it by yourself. Apply. Check out resources that can be valuable to you and, making part of the US and, of course, making part on your own life and dependence as well. See you all again in another video. Take care and bye-bye.